Derek DeBrosse, the gun lawyer.
Hi, gun lawyer here. Next question, I get this a lot, so I want to spend a little bit of time on it, and it's regards to concealed carry insurance. There's a lot of different opinions out there, a lot of different products out there. Ethically, as an attorney, I cannot endorse any of these products. And in full disclosure, I do serve on the Lawyers Advisory Board for the United States Concealed Carry Association. I just want to make that very clear to all my viewers. That aside, my take on concealed carry insurance is I have nothing against it. I've had clients hire me with that insurance and it's proved exceptionally useful to them. Something that cost them thousands and thousands of dollars, over $10,000, they didn't have to pay for because of that insurance. I'm not going to tell you which insurance company that was, obviously, but what I always tell my clients, my friends, my loved ones, my viewers, read the policy that you're purchasing. Make sure you know what you're getting and it's not a smoke and mirrors policy, like anything you would purchase. Understand the cost-benefit analysis. Another thing too, if you're a homeowner, a lot of times your homeowner's insurance policy will cover self-defense if it's within your home or even out to your car. Just understand that a lot of times if it's traditional insurance, it won't pay until you're exonerated because traditional insurance cannot insure an intentional act. These concealed carry policies, for the most part, have a system or a way of getting around that and providing fees up front for the attorney. So just make sure you know what you're purchasing. I have nothing against these policies. I think they do come into play and have a place in society. Just understand and balance that benefit and scenario. I also get the question, is having that type of policy, could that be used against you in court of law? Well, one, I don't know that the prosecutor would ever find out about it. I don't believe it's discoverable in a criminal case. I don't think it's relevant either. So it's unlikely to come up. If the prosecutor does find out about it or does ask you on the stand, if your attorney does advise you to testify, of course, I absolutely would object to its admission into the jury. I don't think it's relevant under the rules of evidence, but there's no clear-cut answer. I don't think the potential risks of having that and it being used against you would ever outweigh the benefits of having it, of course. And I know of no case where prosecutors ever used that against a client or even thought or attempted to use it. And I have a lot of friends that are prosecutors and are gun-friendly prosecutors too, and I've talked to about issues such as that. So I hope that answers your question. Any follow-ups on it or any comments or disagreements, feel free to drop them in the comments below. Just remember, be courteous to everybody and all their thoughts out there that they're being expressed. Be safe out there, everyone. Remember to carry on.